Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about lab scandals. Cases that should have gone to the Supreme Court of Canada, but didn't. The Mother Risk Lab was a lab contracted by the Ontario government and the Children's Aid Society of Ontario for the purposes of analyzing hair follicles from mothers who were deemed to be risks to their children, essentially looking for mothers who were using drugs and alcohol and putting their children at risk. Ultimately, there was some type of a scandal that occurred at the lab, and it was determined that a number of the analyses that were conducted were faulty. A number of parents of children who had been apprehended by the state sued the lab, the Children's Aid Society, and the Ontario government, alleging that there had been negligence and malfeasance and problems associated with the testing had impacted their rights to have their children. The Ontario government and the Ontario Children's Aid Society applied to strike the proceedings, saying that they owed no duty of care to the parents of the children who were apprehended because the lab found faulty results and created faulty results, that essentially they were not responsible for the unlawful actions of the lab that they had contracted to do this work. This absolutely is the type of case that should go to the Supreme Court of Canada. Labs in Canada, contracted by government, are performing a government service. How can it make sense that if they're acting as an agent for the government, they don't owe a duty of care? If you look at other examples where labs are conducting work for government, such as the recent Supreme Court of Canada case involving the disclosure of results in blood and breath testing in alcohol impairment cases, the courts have frequently said that this is information that is first-party disclosure that should be in the possession of the Crown, which means that effectively those labs are agents of the Crown, which means that the Crown should be sued for the negligence that those labs cause. This seems to be the logical extension of the argument, and if this decision is not something that the Supreme Court of Canada feels the need to consider, then it raises the question of whether they believe that their prior cases are wrongly decided, or whether there's a difference between an apprehension of a child from a parent and a registration of a criminal conviction, one of which has a much more significant impact on your life, and a criminal conviction has a huge impact on a person's life. There are so many issues that are raised by this case that the Supreme Court of Canada should have heard, should have decided, and should have given fairness to the parents and to the children that were involved in this scandal, and done right by those individuals by at least giving them the opportunity to be heard. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.